Yesterday, I shared with you the learning materials in respect of Module 1 of Family Law Practice, and I hope you have had time to scan these materials. Module 1 relates to marriage, separation, and dissolution of marriage, as well as the matters that are incidental to dissolution of marriage, including custody of children and disputes relating to property, in particular matrimonial property, the issue of property. So that is the broad topic. I will now give you the scope of the week's work so that you know what we shall cover. I must warn you from the start that it is not possible for us to cover each and every aspect of a given module in a given week. So we would like you to cover whatever we do not cover in class, or if we cover only to a degree, to read on your own. Since you are graduates of law, you are equipped with the knowledge of law. Simply revise, and if you did not cover it at university, find a way of doing legal research so that you are up to date with all that you are required to cover in the week. But it is not enough for you to know the law. It is important that you should be able to apply it so that you are able to advise on appropriate remedies and to draw the relevant documents. So whatever else that we shall not cover during this week, you are required to know. Please go an extra mile beyond the workshops. Now at LDC, the major training outcomes are, we emphasize comprehension. You must read and understand. See what is material as a lawyer, not as a lay person, but as a lawyer. Apply the law to the facts of your client's case so that you are able to identify their grievance or cause of action, to identify the remedies that they have, the procedure for obtaining those remedies, the relevant forum, and the necessary legal documents. So the knowledge of the law is very important because that is what you are required to apply. But the major thrust of the training is skilling. And the other area is ethical considerations, because without values, you will not be able to practice law as a lawyer or as a judicial officer. Even if you will be you'll be taking up a career in legal advisory work. You need to work professionally and ethically. So all these important aspects are incorporated in these workshops. The scope of the week's work. We will be covering the types of marriages that the law recognizes. The church marriage, civil marriage, customary marriage. The law also recognizes the Hindu marriage because at the time these laws were made, our society was so homogeneous. The Indians were still a part of us. And so you are required to know about Hindu marriages as well, and also how they are dissolved. There was one case concerning dissolution of the Hindu marriage that was decided by Justice Kasule. The grounds for divorce are essentially the same. But I must warn you that although we have not provided for it in our workshops, do not be surprised if you are examined on a Hindu marriage during the oral examinations. So please go further than what the workshops provide for. Secondly, when you treat marriages, remember to distinguish avoid marriage from avoidable marriage. What is the meaning of a void marriage? What is the meaning of avoidable marriage? Are you able to apply the principles of law to be able to distinguish between these two? And what remedies do people have in case they went through a ceremony of marriage that was a nullity ab initio? Or if the marriage is voidable, what are the legal implications of such a union? Thirdly, the matter of separation. For the Christians, separation is provided for in the Divorce Act. And you know there are two types of separation. It may be judicial separation by order of court on the grounds that the law provides for, or it may be out of court. And therefore, in that case, then it is by agreement of the spouses. For skills, we are particularly interested in you identifying the grounds for separation. For purposes of a judicial separation, to be able to draw a petition for judicial separation, which therefore should disclose the grounds for separation known to the law. For the agreement, we would like you to be able to draw a separation agreement that is proper. Reading that agreement, we should be able to know that the parties to this agreement are married and that there's a valid and subsisting marriage, that there's a cause for separation. Then we would like to see those indispensable features of a separation agreement. Do you know what a Damcaster clause in a separation agreement means? Do you know what a non-molestation agreement means? If the facts provide for property, are you able to meaningfully make provisions in that agreement on property? What about the issues of custody of the children? What about the duration, etc.? The fourth matter area is dissolution of marriage. We would like you to know the law governing dissolution of each type of marriage that the law recognizes: the church marriage, the civil marriage, the Islamic marriage, customary marriage, the Hindu marriage. What are the grounds that the law provides for? What is the procedure? For the Islamic marriage in particular, can the parties dissolve their marriage outside court? If so, what are the grounds? What is the procedure applicable? How do Muslims register their divorces? What is the role of the Qadi courts in divorce under Islam? And if they have to seek dissolution of their marriages from secular courts, how will they proceed? What is the law you will apply? What is the document that you will file before court? And which courts would have jurisdiction? We would like you to note that the Muslims can divorce outside court and it will be perfectly a valid divorce, but it is subject to the principles of Islam, the rights that Islam recognizes. We have invited guest speakers from the Uganda Muslim Supreme Council who will address you on Thursday afternoon from 2 to 4 p.m. on dissolution of an Islamic marriage. We have asked them to cover all those pertinent areas, the types of divorce that Islam recognizes, the grounds, the procedure when the spouses divorce themselves outside secular courts. What happens when they validly divorce? You know, we are now looking at the evidence of divorce. If you ever visit a Uganda Muslim Supreme Council, you will see huge registers of divorce. They are not the only registers you will see. There are registers of other matters as well. But these sheikhs will be able to give us further insight so that we can understand our research, so that we can enrich it. Please do attend and pay attention so that you can ably understand. Now, apart from Islamic dissolution of Islamic marriages, we're also interested in a dissolution of customary marriages, because that is one of the types of marriages that our laws recognize. And so many people are validly married in accordance with custom. So when the remedy is dissolution of a customary marriage, what do you do? What advice would you give to the parties? Supposing that they do not want publicity, they do not have the money to hire a lawyer, and they badly need a remedy. Can you provide them a remedy outside court? Must customary marriages be dissolved by court as a matter of law? They can be dissolved in accordance with the customs of the parties. Or if their customs are different, you know the law. You know the law to apply. Now, if you have to petition court for an order dissolving a customary marriage, which court will you petition? Is it the subordinate courts, the magistrate grade 1, magistrate grade, chief magistrate? Is it the high court? We would like you to look at the law and give us your well-reasoned positions. Fortunately, we now have cases decided by the High Court. Some of those cases, with the greatest respect to the honorable judges, are a little misleading, but we want you to carry out your research first, because you are lawyers, just like your teachers. Then we hear your views on the positions of some of those High Court decisions. But at least a customary marriage can be dissolved by court, magistrates, high court. Look at the law, the Judicature Act, the Constitution, the Magistrates Court Act, and case law. All right, lawyers, when we have dealt with dissolution of marriage, there are matters that are incidental to dissolution of marriage. For example, the issue of children, the issue of the marriage or the children. Custody will always be a very important issue for a lawyer handling a divorce matter. Then today, the issues of property on dissolution of marriage are very critical. You will not read a high court judgment today on dissolution of a marriage and fail to see an issue on property. Now, the issues you must determine as lawyers are whether the property in question in your client's case is matrimonial property. If it is, the parties' rights in this property. You know the principles of law to apply, starting with the Constitution, and about 5 principles that you will pick from case law. We have the Supreme Court case of Julius Rabinumi, Hope Bahimbisomwe. No, in the Supreme Court, it is Julius Rabinumi against Hope Bahimbisomwe. But we are also drawing from English cases. So please read the Constitution, pick all the principles of law on on matrimonial property. When you have these principles, apply them to the facts given so that you are able to determine the respective parties' rights in the properties in question. Lawyers, skills. We are very much interested in skills because LDC is training future practitioners. We would like you to draw the relevant documents. For example, in workshop number 1 that is dedicated to marriage, there are certain documents that we would like you to draw. We are interested in the substance of those documents. Workshop number 2 is dedicated to dissolution of marriage, all the types of marriage except the Hindu marriage. But in your petition for divorce, we will always give you facts on property so that you apply the principles governing matrimonial property to the facts you are given, determine the spouses, the rights of the warring parties, And when you have determined their rights, they must translate into certain declarations in the divorce petition. You cannot protect your client if you seek only an order dissolving the marriage, decree nisi. What about the property? If you have understood the principles of law on matrimonial property and correctly applied them to the facts, you should be able to design proper declarations in the petition that will protect your client. For example, this is only an example, it is not related to the facts in the workshop. If on application of the principles you have determined that your client, who is the husband of the respondent, is the owner of the property in question, and that the respondent did not make any contribution whatsoever, you must seek a declaration in the petition. For example, that the property described as this and this, for example, if it is Milo land, block this, plot this at this place, is the property of the petitioner, and the respondent has no interest whatsoever in the said property. You must seek those declarations. If you do not seek those declarations, the court will not give your client a remedy, and it will not be possible to correct that mistake on appeal. That is if you have a right of appeal. If you have that right, you cannot undo certain mistakes. So lawyers, it is very important that you read, understand the law, comprehend your facts, correctly apply the law to the facts, and identify the remedies, the right forum, and draw proper documents that take care of every aspect of your client's case. So we would like to see, apart from you seeking a dissolution of marriage in workshop 2, the children, we want to see the remedies you seek in respect of the children. We want to see the remedies you seek in respect of the property. Please read case law. When you read case law, you learn how to draw these documents. If it was a judgment by a superb judge, everything will be explained. If the petition the lawyer filed was superb, you will see how they sought the declarations in their petition. So for that matter, lawyers, if you have access to pleadings from good law firms, please make good use of them so that you learn how to draw these documents. For your information in your examinations, we ask you to draft orally. We can ask you to draft those, just the declarations. We will give you a set of facts and we will ask you to draft only the declarations so that we can judge your appreciation of the law, correct application, and ability to protect your client by drawing proper documents, seeking proper remedies. Now, in addition to that skill of drawing the necessary documents, you will be presenting and prosecuting your petitions before the appropriate fora. So when you have drawn proper documents, you should have opportunity to file them in court, our moot courts, and on the day of the moots, prosecute your respective cases as counsel for the petitioner or counsel for the respondent. That may not be possible this week because this is the first subject and the head trial advocacy has to introduce you to the subject. But in future, you will be prosecuting your cases. Now, the other area is alternative dispute resolution. As you are aware, it is the policy of our government and the judiciary is enforcing it, that as far as possible, we should look at a alternative dispute resolution as a mechanism of settling disputes for the so many advantages, with save courts time, resources. We are poor, Ugandans, we are poor. Over 50% of Ugandans cannot afford lawyers' fees. Some people do not even have the money to pay court fees. So when you look at the facts in the workshop and you observe that it is possible to seek a remedy by way of alternative dispute resolution, we want you to advise us on such a remedy. Then number 8, the ethical considerations. Because you are going to be practitioners, we expect you to learn values. These values are provided for in the Advocates Act, the Advocates Professional Conduct Regulations, and in the Advocates Students Practice Regulations. Because you are students pursuing this course, the law under those regulations permits you to practice law to a certain extent and within regulation as those regulations provide. So you must have a student's practicing certificate. So you should know the kind of matters that you're not permitted to handle, and even if you are permitted, what you should not handle. But because we are training you to be advocates, to be legal advisors, to be judicial officers, there's a lot more that you should know apart from the requirements of the Students' Practice Regulations. So read the Advocates Act, the Advocates Professional Conduct Regulations, and the Students' Practice Regulations, and know negligence, confidentiality, avoid conflict of interest. It can arise in so many ways. If you are a male lawyer, please do not fall for your female client. It will make you blind to the things that you are supposed to see and to present impartially before court. If it is a lot of money involved, do not fall for her and mislead her with the view of cheating her and enriching yourself. There's so much you should not overbill, exploit your client's ignorance and ask for a lot of money that is not justified, because there are scales for determining how much money you're entitled to as a lawyer. So please read those laws. And when you go through the facts, if you are required to note ethical pitfalls, note them so that you learn. By the time you start to practice, you will know what to avoid. It is very important, lawyers, to build a good name, a reputation. We do not want you to go to jail for the world to see you on TV. You've been asked to remove your shoes and you've been handcuffed and you're being led into a police cell or, Luzira. No, it should never happen. We do not want your practicing certificates to be cancelled. That is how you'll be earning a living for those of you who will be practicing as advocates. So there are these things that you must avoid. When you have a good name, it will go before you. It will bring you the business that you need to survive. All right, lawyers. So there are other areas that we are asking you to explore in detail on your own. Domicile, the meaning, the types of domicile, and the importance of domicile. You realize it is important for each and every module. Domicile, marriage, divorce, even the second module, even succession. Read further on consummation of marriage. What does it mean? If a marriage is not consummated, what are the legal implications? Case law explains the meaning of consummation in graphic detail if you read K against K. But it's important that you should know the legal implications, because if the marriage is not consummated, as a lawyer, you know the remedy to seek for your client who is aggrieved by non-consummation. The legal implications of marriage, the rights and duties of married people, the suspension of conjugal rights. This one is still on our statute books, but it is very difficult to enforce an order of restitution of conjugal rights for reasons you can guess as lawyers and human beings. This one is covered in the workshop, but we would like you to understand it very well. That is the procedure for obtaining a special license in order for people to marry under a special license, the procedure for obtaining licenses for places of worship. Why am I asking you to understand this? You'll be making very good and quick money. These pastors of these born-again churches are going to ask you to represent them in these matters. Then there are people who will be wanting to get married much sooner than the law makes it lawful for them. You'll make some good money because these people are not lawyers. The proprietors of these churches are not lawyers. Please visit the URSP websites. The details are clearly explained. Please read about all the other reliefs that the law provides in matrimonial proceedings. Now let's go to the specifics of each workshop. Lawyers, workshop number 1 is dedicated to marriage. The learning outcomes are that by the end of Monday, 5 o'clock, each one of you, intake 2, should be able to determine existence of a marriage. If you ever come across any set of facts or interview any client, you should be able to determine whether the union that he or she is describing amounts to a marriage recognized under our laws. The other critical learning outcome is that you should be able to draft the various documents relating to marriage. For example, a petition seeking a declaration that the purported marriage is a nullity. It's not a question of drafting. You must know the law. What is a void marriage? From the facts of this case, what makes it void? Because you must plead them in order to show that the marriage indeed is void. All right. Then, relating to civil marriages in particular, some people will be coming to you, they wish to celebrate a civil marriage for the advantages it presents, but they don't know. All they want is to get married before the registrar, contract a civil marriage. When they go to that office, they are asked for certain documents, an affidavit, essentially that affidavit is to show that they have, they're not married, but there are other requirements under the Marriage Act. That is what that affidavit essentially proves. We would like you to read those sections and also reflect on the nature of a civil marriage and how it is conducted so that you understand the contents or substance of that affidavit. And when people come to you, you should be able to draw it and charge your good money for it. You just sit on your laptop and you draw it in a matter of minutes, not even an hour. Make sure it is commissioned, and you'll charge your money just like that. But if you have not understood the sections, you'll not be able to draw us that good affidavit. All these are skills. Now, the third learning outcome is that regarding these marriages, the essential skill apart from drawing that petition is you should be able to present that petition before the relevant forum. When you look at the facts of your client's case, you should be able to determine the court that has jurisdiction. Present it, pay court fees, fix it for hearing, prosecute it. If you are counsel for the petitioner, you should be able to know what to do. Do not worry, you'll get to know with time. When you deal with workshop number 1, you should reading those laws I told you on ethics. You should be able to know from next week the kind of things you should avoid if you want to be a good practitioner. Okay, now workshop number 2, as I told you before, is dedicated to dissolution of marriage and matters incidental to divorce, particularly the issue of the marriage or the children and matters of property, depending on the facts relating to the property in your client's case. So the learning outcomes are that by end of Wednesday next week, every student should be able to identify grounds for divorce. Depending on the nature, the type of marriage you're dealing with, you should be able to determine the appropriate forum where you will seek the remedy. If on the facts of your case, the remedy should be sought from court. Remember, it can be outside court with specific reference to the customary marriage and Islamic marriage. You should be able to draft a very good petition for dissolution of marriage, which discloses grounds, which discloses the proper forum, which seeks remedies on children and on property if there are issues of property in your client's case. And you should be able to present the petition before court and to prosecute it if you are counsel for the petitioner. And if you are counsel for the respondent, you should be able to file an answer to the petition and to prosecute your client's case accordingly. Then lastly, we want you to identify the pitfalls, in terms of professional conduct and ethics, which you should avoid. Practitioners. All right, lawyers. For workshop number 3, it is it is always for training you in trial advocacy. So it is usually a moot scenario. In this week, we will not have a moot because a trial advocacy team will be introducing you to that subject. It will be a different exercise altogether. The head trial advocacy will issue instructions for that training. So lawyers, that is the synopsis of next week's work. Please read individually, carry out your legal research individually, then get into serious groups. You have no business teaming with people who don't read, who have nothing of value to give to the group. Then get into group work even before you do firm discussions, so that by the time you enter join those groups, some people just keep what others say. They don't even know the correct thing. They don't even know the facts. That is dangerous. If you are the kind of student who reads, assembles her reading materials, legislation, read, highlight the sections. When you highlight physically, you also highlight mentally. You never forget. Assemble your cases. Highlight what is material to you. Create a section, module 1, in your box file. Assemble all your materials, because you will not enter those examination rooms with a laptop or phone. It will be in your head, and then for quick refreshing your memory, you can flip through the file. A student who has done that never carries out research in the examination room. The moment they have understood the facts, the issues come naturally to their heads, and they know what to do. Please get into the habit of drafting these documents yourself. Learn. Let your fingers learn to do it, and let your head do it mentally. Okay, let me stop preaching, but I hope you get a very good direction in how to pass the bar course effortlessly. All right. So I would like to thank you so much for listening, and I would like to thank the LDC IT experts who have made this session possible. See you next week. Thank you.